All right, great. Good morning, ladies and gentlemen. We're very pleased to have with us today two senior officials from the International Court of Justice who are here to talk with you about the court's work and its operations under the current conditions of the COVID-19 pandemic. We are pleased to have the president of the ICJ, Judge Abdulqawi A. Yusuf, and Philippe Gautier, the registrar of the ICJ. And we'll start with them giving some remarks, and then we'll open up the floor for questions. Judge Yusuf, the floor is yours.
Unfortunately, be in New York this week due to the COVID-19 restrictions. But since we resumed this press briefing only last year, after a 20-year hiatus, we did not want to break with this tradition again. We are therefore happy that you were also able to attend it. As you well know, the main function of the International Court of Justice is the peaceful settlement of disputes through the law. Another function of the court is to provide advisory opinions to the other principal organs of the United Nations and to the specialized agencies of the UN. Since 1945, when the court was established as the principal judicial organ of the UN, 178 disputes were brought before it. And the court has delivered on these disputes 133 judgments. Of course, some of these disputes could have escalated into major armed conflict. The court has also been able to resolve some ongoing armed conflicts through its judgment. These disputes among states concerned land frontiers, maritime boundaries, territorial sovereignty, the prohibition on the use of force, violation of international humanitarian law, diplomatic and consular relations, civil aviation, human rights protection, almost all aspects of international relations. The court has also delivered 28 advisory opinions since 1945. And the last one was the one delivered in February 2019 on the legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965. The court has been receiving more cases than ever before in the last few years, to the extent that if you compare the number of cases submitted to the court in the last 20 years to those submitted to it in its first 55 years of existence, they are almost the same. So the court is very proud of the great confidence and trust that member states continue to place in its work, which is of course obvious from the number of cases submitted to it, the number of states also that have consented to its jurisdiction, and even more, the common compliance by all states parties to disputes with the decisions of the court. Since our last briefing in October 2019, the court has been dealing with 8 of the cases pending before it. It has delivered 4 judicial decisions, and it currently has 4 other cases under deliberation, in relation to which 4 judgments will be rendered in the coming months. The biggest challenge that the court faced this year was the COVID-19 pandemic. The court, of course, is an old institution, and like many other such institutions, we are used to working together in person, holding in-person hearings also, and talking to each other without using a computer screen. COVID-19 has disrupted this old tradition of in-person meetings and in-person hearings. But the court was able to react quickly in order to continue to discharge its functions under the Charter of the United Nations. We did so by putting into place the relevant technology to hold remote meetings and hearings. And all the members of the court participated actively in this reaction and in actually bringing this change, bringing about this change, which, of course, as you can imagine, has put the court squarely into the 21st century through the increased use of digital technology in all its judicial activity. But for this purpose, the court had to amend some of its rules of procedure in order to clarify the legal framework governing its new methods of work based on remote technology. And the court, and this, of course, represents an unprecedented development in the manner in which the court conducts its judicial work. As a result, the court has been able to maintain this year its judicial output at the same level as in previous years, despite the difficult circumstances brought about by the pandemic. Only during the month of September, the court was able to hold 2 hearings remotely. And before that, another hearing was also held remotely by the court. Today, 15 cases are pending before the court, 4 of which, as I said, are under deliberation. All 15 cases are contentious cases. These cases come from all parts of the world and involve a wide variety of member states from all 5 UN regional groups, including 6 states from the African group, 4 from the Asia Pacific group, 4 from the Eastern European group, 8 from Latin American and Caribbean group, and 2 from the Western European and others group. As these numbers suggest, although the court will be celebrating its 75th anniversary next year in April, it remains a dynamic institution that is continuously contributing to peace and harmony among nations through the application of the law. It is thanks to this energetic spirit and innovative attitude that the court has been able to move very quickly to the use of digital technology in all its judicial and administrative activities in a very short span of time, and to avoid the disruption of its activities by the restrictions arising from the COVID-19 pandemic this year. Before taking your questions, I would like to invite the Registrar of the Court to say a few words. Mr. Gautier.
Thank you, Mr. President, and good morning from The Hague. As the President mentioned, the past months have been a challenging period of time, and I'm glad to note that the Registry, it means the Secretariat of the Court, was able to react swiftly in order to ensure that the Court could continue its activities. After 2 weeks, teleworking was implemented fully. After 1 month, the Court could held deliberation and hearings using a video link. And I would say from a judicial point of view, it's business as usual, and the court is ready to deal with new cases. I would like to add also that if hearings could take place and quite successfully, it's also due to the cooperation between the registry on a technical level with the delegations of states appearing before the court, both applicant and respondent, and it's rewarding. I would just like to add 2 points briefly. Regarding the press, I would say that we are ready to provide information on the court activities on a more regular basis, and there are cases which are quite high-profile cases, and there could be press briefings taking place on a more regular basis in The Hague or virtually. The second point is the anniversary of the court next year, 75th anniversary, and we would like to open the court to the public. Sure, in light of the current circumstances, physical presence will not be necessarily possible, but we will make sure that the gates of the Peace Palace, that's the place where the court is located, will virtually be open. And there is a virtual guided tour which will be posted on our website pretty soon. There is a film also on the court and the publication of a book, not for academia, but rather for the general public and journalists to show and to underline that the court is a cost-effective instrument and that the peaceful settlement of disputes should be encouraged and promoted. Thank you, Mr. President.
Okay, thank you both. So I will now open up the floor for questions. Please indicate in the chat box whether you want to ask a question. Right now we have two people on the list. So I'll first turn to Jan Hennep from AFP. Hello, Jan Hennep from AFP.
Good afternoon. My apologies for that slight little technical difficulty. Good afternoon, everybody. Good afternoon, Your Honor. First of all, thank you very much for speaking to us again. It's really nice to talk to you. And in the 10 years that I've been covering the ICJ as a journalist, it's always nice to have this kind of contact. And I applaud your efforts in the future to talk to us some more. I'm sure we will. I have a bit of a different question. There was a reference to the 75th anniversary of the ICJ next year, but as you know, next month marks the 75th anniversary of the opening of the Nuremberg trials. And I know that the ICJ doesn't deal with international criminal law like the International Criminal Court does. But my question perhaps is this: do you think what would your message, first of all, from the ICJ be 75 years after the Nuremberg trials, first of all, and secondly, could you tell me a little bit whether the outcome of the Nuremberg trials had any influence, for instance, on the jurisprudence of the International Court of Justice?
Well, I thank you very much, and I would take the answer. I would divide perhaps the answer into two parts. The first part, with respect to the principles, I will answer it, and the second part, which actually might be of interest to you, is that the archives of the Nuremberg Tribunal have always been with the International Court of Justice, and they were recently digitalized. And so I will ask the registrar perhaps to address that aspect of it, which actually shows you the close links between the Nuremberg trial and tribunal and the court as the first judicial international institution, permanent judicial international institution at the world level. So with respect to the principles, the Nuremberg principles have, of course, influenced jurisprudence all over the world. Both international and domestic jurisprudence. And the court has always looked at them, although the court does not deal with criminal law, issues relating to humanitarian law, to international humanitarian law, come before our court. And in those cases, the principles of Nuremberg can be an inspiration to the work of the court. Of course, more recently, the International Criminal Court has been created as the first permanent international criminal court in the world. But our court has contributed a lot to the development of international humanitarian law and also to the development of human rights law. And so there is not much of a gap between the principles applied by the Nuremberg Tribunal and some of the principles that our court had to apply and rules that our court had to apply with respect to humanitarian law and the protection of human rights. So I will now give the floor to Mr. Gautier. So I will now give to address the other aspect of your question.
Thank you, Mr. President, and thank you for this question. Indeed, from the documentary point of view, there was a decision of the military tribunal Nuremberg in '46 to deliver the archives to the court, and it took place in March '50, and it is kept with the registry, and you may find information on the website. If you look at the website under registry library, there is a specific section entitled the archives, and there is a booklet which is attached. Recently, we have placed that on the website because of the anniversary, I would say. An information booklet was uploaded and is available in different languages, giving an overview of what has been done with respect to digitization, as the president mentioned. And last year in Paris, there was a ceremony to mark the steps which were taken in this matter. Thank you.
Farhan, over to you.
Okay, great. Thank you. And next person on the list for questions is Amanda Price from Al Jazeera. Amanda, the floor is yours.
Hi, thanks very much to you both for doing this briefing. A question on a case that the Netherlands is hoping to bring before the court. They said back in September that they want to launch proceedings against Syria under the UN Convention Against Torture. Syria has responded and rejected that action. So correspondence between these two parties has begun. Where do things stand now as far as the court is concerned? What is the status of the process?
We have heard, like everybody else, about the steps taken by the Netherlands government. But the court has not been formally notified by any state that a case will be brought before it. So we are not up to now informed of a case that will be brought by the Netherlands before the court. We are just reading the same stories in the press that you must have also been reading, but we are not any wiser than that.
Okay. Unless Mr. Gautier has anything to add, we'll turn the floor over now to Abdulhamid Sayam.
Thank you, Your Honor. I have a couple of questions.
Hold on, Abdulhamid. Hold on, Abdulhamid. Mr. Gautier had something to add. 1 second.
So sorry, it was simply to say that I had nothing to add. Thank you.
Okay. All right. Now over to you, Abdulhamid. Thanks.
Oh, thank you so much. Your Honor, my name is Abdulhamid Sayam from the Arabic daily Al-Quds Al-Arabi. I have a few questions. One of them is I want to clarify some terms you used and to see the difference. and which is more powerful? You talked about decisions, you talked about judicial decisions, you talked about judgment and advisory opinion. So I want to see which is more binding or which is more powerful. My second question is about a case. I believe that the Palestinian Authority brought it before the judge, the ICJ, which has to do with the U.S. decision to recognize Jerusalem as the eternal capital of the State of Israel. So if that case is pending or if you have received or not, I'm not sure, but that's what the PA had been talking about. And the third, do you see that as a trend now of more violation of international law, where a country like the US recognizes the Golan Heights as part of Israel? They recognize the settlement is not illegal, and they banned there was a ban on investing in these settlements, so that was lifted. Modi of India decided to annex Kashmir, which is illegal according to international law, and many other similar cases. Do you see that trend of that becoming, some populist leaders are trashing international law, what the ICJ can do about it? Thank you very much.
Thank you very much. Let me try to address all three questions. First of all, with respect to the first question, decisions cover mainly judgments and orders issued by the court. And judgments and orders are binding. Judgments refer to the substantive judgments or judgments on the merits of a case, or judgments on jurisdiction of the court. Whereas orders are usually orders on provisional measures of protection, for example, until the matter is decided by the court. And that also is binding on the parties. The binding nature of all the judgments and decisions of the International Court of Justice is in the Charter of the United Nations. And parties to disputes are actually required under the Charter to respect the binding nature of the judgments of the court. Advisory opinions are different. They are, as their name indicates, an advisory opinion given by the court because it is consulted by another organ of the United Nations, like the General Assembly, the Security Council, or by a specialized agency of the United Nations authorized to seek an advisory opinion. Now it is up to the organ which actually requested the advisory opinion to use it the way it sees it fit for the performance of its own function. But what the court does is just to explain and elaborate on the legal issues pertaining to the opinion sought from it. In other words, the court explains the law and says, this is what the law establishes. This is what the law indicates on that question. But the advisory opinion is not binding by itself, but it can be used by the organ which requested it from the court. The case brought by the Palestinian Authority is pending. It is one of the 15 cases that are actually pending before the court, and that will be taken up for examination by the court in the near future. Third, the trend you have spoken of violations of international law. You know that we are a court of law, and therefore for us to say that something constitutes a violation of the law takes quite some time. We need to study it. We need to look at the arguments of the parties, the party which alleges that there was a violation, and the party which claims that actually it has not violated anything. So it's not so easy for us to characterize the actions of a state or of a leader as a violation of international law. It's not something that we do off the cuff like this, in the same way that perhaps the public or journalists may do. We are a court of law, and we have to be sure of what we are talking about when we say that there was a violation of the law. So our approach is quite different from the one you have just described.
Thank you.
Thank you very much.
Mr. Gautier, do you have anything that you'd like to add to that?
Yes.
Simply to mention, since there was the case Palestine instituted by Palestine, of course, as for any case brought before the court, there are documents and information made available to the public, and which may be found on the website of the court. So I may invite you to consult regularly for those interested by case. And for example, with respect to this case, you will see that the application is made available, and that the first phase of the case will be devoted to the jurisdiction and the admissibility of the application of Palestine. That's available on the website. Thank you.
Thank you. And one of the journalists had some audio problems, so I will ask a question on behalf of David Morales right now, which is the following. In the case Obligation to Negotiate Access to the Pacific Ocean, Bolivia versus Chile, what could Bolivia have done better in order to get a favorable judgment? What did you miss in Bolivia's written and oral argumentations? Judge Yusuf, I'll ask that to you.
Thank you very much. I think that everything that had to be said was actually said in the judgment. And I believe that Bolivia did its best to present its arguments in the case. And it did present excellent arguments. But the law is what it is. And the court, of course, ruled that Chile did not assume an obligation through the correspondence, through the statements that were presented before the court by Bolivia, to give access to Bolivia to the Pacific Ocean. And the assumption of an obligation in international law requires certain actions by the concerned party. And therefore, I don't think that one should look at this as a failure on the part of Bolivia, or a failure in the presentation of arguments by Bolivia. Bolivia did its best and made its argument, but the court also had to decide what it decided, which is based on the law.
Thanks very much. I do not see any further questions. I would, at this point, like to thank once more Judge Yusuf and Mr. Gautier for your presentations. And thank you all for attending. And I wish you all a very good weekend. Thanks very much to both of our guests.
Thank you very much, Farham, for hosting us. Thank you a lot. We are really appreciated.
Thank you.
Thank you.
Have a great day. Bye-bye.
Bye-bye. Bon weekend to you too.